Hey guys, how are you all? I hope all of you are fine. So in this video, friends, I am going to talk to you regarding judicial activism. Now, what is judicial activism, friends? And I am going to talk to you about judicial activism in the context of India. Okay. Now, first of all, this concept of judicial activism originated in the United States of America. Okay, this originated in the United States of America, and this was introduced to India in 1970s. Now, the persons who had a major role in the introduction of judicial activism in India, their name were Justice V.R. Krishna Iyer, then Justice P.N. Bhagwati, Justice O. Chinnappa Reddy, and Justice D.A. Desai. It is being said that these were the persons who laid the foundation of judicial activism in India. What is judicial activism, friends? This is a proactive role played by judiciary to protect the rights of the citizen against the excesses of the legislature and executive. This is one thing. Or you can say that anything that promotes the justice, anything that promotes the fair play for the citizen of India, that comes under judicial activism. That is, if the judiciary is doing anything which promotes social and economic or any sort of justice for the people of India, for the society as a whole, then that thing is said to be judicial activism. So you can understand that the contours of this word, the contours of this phrase judicial activism are very, very wide. They enlarge among, they include among it a whole lot of areas, a very wide and very diverse field. Coming forward, this judicial activism is also known as judicial dynamism. This judicial dynamism says that there is no judicial restraint. Now, what is judicial restraint, friends? Judicial restraint is that practice by which the judiciary strictly confines itself to the interpretation of law and pronouncing judgments on the cases which are coming in front of it. But judicial activism is totally in opposition to the judicial restraint, where the judiciary is coming out of its conventional sphere, and it is ingressing into the spheres of executive and legislature for obviously positive reasons. Because when you are transgressing for negative reasons, then it becomes judicial terrorism, not judicial dynamism or judicial activism. Now, what there are two scenarios that I will tell you what qualifies as judicial activism. The first scenario is that judicial activism is a sort of way, is a trend which you can say encourages the judges to exercise their judicial power, which is not based on their normal adherence to the judicial precedents. That is, they depart from their normal course of action and they rule in such a manner that their rule or the whatever decisions that they are giving, that decision is in favor of progressive and new social policies. Okay, now we all know, friends, that the lawmaking, policy making is the domain of legislature and policy implementation is the domain of executive. But if the judiciary is leaving its own domain and coming into the field of implementing the policy, or suggesting something towards the policy, or basically propounding one or two provisions of the policy, then obviously this judiciary is transgressing into the domains of executive and legislature. So this is one sort of judicial activism, you can say. This can be towards things like social engineering. Okay, and they represent intrusion in the legislative and executive spheres. Judicial activism is the practice in the judiciary of protecting or expanding individual rights through decisions that depart from established precedent or are independent or opposition to established convention or legislative intent. This is just a phrase. The meaning is the same, friends. This is one meaning you easily understood, that transgressing your conventional way of action in order to do things that may transgress into the fields of legislature and executive, but it is very much productive and progressive for the society. Now, why judicial activism is important? We should know that if the judiciary is leaving its sphere of action, it's going into uncharted territories, then what is the reason why it is important that judiciary should go into uncharted territories? Because especially our Indian constitution has very much clearly said that obviously that legislature is separate, executive is separate, judiciary is separate, and all are equal in power. Okay, so they have their own spheres of influence, they have their own sphere of lawmaking, they have their own sphere of decision making. Then one should not translate the fields of other, but still judicial activism nowadays in modern day India and also the modern day globalized world is being taken in a very positive note, this judicial activism. So if something is taken in a positive note, despite it is transgressing the powers of some other fields like the executive and legislature, then there should be some reason for it. Now we are going to get why it is important. The very first reason is that, friends, many times this happens that the government which we choose, okay, in India that Lok Sabha is chosen. Lok Sabha is directly elected, so it represents the legislature, and also Raj Sabha also represents the legislature. The members of the Raj Sabha are indirectly elected by the members of the state legislative assemblies. Okay, so this forms of a legislature at the central level, and obviously what is the executive? It becomes the council of ministers. So many times happens that this legislature and this executive, they are not performing the duty in a manner in which they should perform it. So in that case, judiciary has to step in and correct the wrongs that are being committed by the legislature and executive. So this is one reason why the transgression of judiciary in the legislative and executive fields is important. Coming forward, citizens of a country nowadays, they look towards judiciary in a very progressive manner. They think that nowadays in India, that education levels are going up. The understanding of the people towards the problems of the society is increasing. So because of that, now people are going to understand what is their problem, and people also know that what is the problem of the executive and legislature. People know that the political party which is in power, it is bound by certain constraints. Why it is bound by certain constraints? Because the political party has also to look at the next elections, that whether they will be able to win the next elections or not. So people know that it is the judiciary which can, pronounce a very progressive judgment in a matter of, less time when compared to legislature and executive, because many important legislations have been pending with the legislature for decades. Okay, friends, but now judiciary is something which can, you can say, pat the legislature. It can basically instruct the legislature to do something positive, and if instead of that the legislature is not doing something positive, then judiciary can itself take action and do it. So this is why people are looking up to judiciary, so that judiciary should make decisions which are useful and beneficial for the society and people. Next is judicial enthusiasm. Okay, friends, nowadays judges are, very much encouraged to participate in social reforms with the changing times. Social reforms with the change, because nowadays many times you see that judges are, so motive saying, and in the cases ruling, in the decisions of the cases, they are saying that okay, women's situation is bad, it should be improved. A lot of new things are coming from the judiciary, a lot of innovating things are coming from the judiciary. So what is happening nowadays? The conventional concept of locus standi is getting violated, and now suo motu cognizance is being taken by the judiciary. Now what is locus standi? Locus standi is that convention phenomena, friends, that if a dispute comes to the court, for example, so locus standi says that only that person can bring the dispute to the judiciary who himself is aggrieved. That is, for example, if a person A, he is aggrieved of something, so only the person A can take his problem to the court, not anyone else. But that the Supreme Court can suo motu, or any court can suo motu take the cognizance of that matter, or any other person on behalf of that person who was aggrieved can file a case in the judiciary and get justice for it. So judicial activism also implies the concept of violation of the principle of locus standi and entertaining the cases on suo motu basis, or the cases may be filed by anyone else. It is not important that it should be filed by the person who is aggrieved. Okay, so this is one thing. Also many times we see that there is a sort of legislative vacuum is there. No, many times it happened that important decisions are not being taken for the judiciary for a long period of time. They are left pending. So it becomes important for the judiciary to step in and fast track the process of legislative. And the Constitution of India itself has certain provisions, it is being said, that gives the judiciary a lot of discretion to to take decisions. That points I will be going to take up later in this video. Coming forward, why some more reasons of why the judiciary can use its judicial activism power to transgress the powers of executive and legislature. What happens that if the legislature is straightforward failing to complete its responsibility, then obviously judiciary has to step in and do something. Then comes, if there is a hung legislature. What happens in a hung legislature, friends? A hung assembly, you can say that, for example, elections took place and a coalition government is formed. Now what is happening, that no party has a clear-cut majority, and in the coalition government, okay, the main government is not getting support from its partners to take important decisions. So important decisions are not being taken because the incumbent government doesn't have a clear majority. So in that case, obviously the legislature is not able to take decisions, and there are many reasons why the legislature is not able to take decisions. It can be, that it may hurt the sentiments of a particular class or community, or it may reduce its vote base. So legislature has a lot of reasons why it is not taking decisions. But at this point of time, if there is a hung assembly, if there is not a clear majority, if there is a coalition government, and the decisions are not being able to taken by the legislature with a proper mandate, with a clear mandate, with a firm hand, then judiciary can step in and fast track the process. This is what judiciary can do. Obviously, those in power, if they are afraid of taking honest and hard decision, or if they fear of losing power, then in that case, the courts can step in and do things. Friends, some years back there was case that civil servants were very much pressurized by the bureau, by the politicians to act according to them. Those civil servants was being said that by the politicians that you have to work according to us, and even if it is wrong. And civil servants, obviously, many times there are many honest civil servants which are not going to go a wrong territory, in a wrong territory or an uncharted path. So in that case, Supreme Court came to the rescue of these civil servants, and Supreme Court said that okay, if you are being harassed by any politician, if a politician is ordering you something wrong, then ask for that order in writing. And if he is not giving that order in writing, then don't do that thing. This Supreme Court said. So obviously Supreme Court came in the support of the civil services, in the bureaucracy, to protect them against the politicians, that is against the legislature or against the executive, you can say. So this is what the role the Supreme Court, or you can say the judiciary as a whole, is taking. Is playing, and it is very much important, for the healthy functioning of our democracy. This is basically was the concept of judicial activism, friends. One thing I need to tell you, that in this subsequent video I'm going to tell you about the public interest litigation, friends. The best mechanism through which judicial activism is being exercised in India is public interest litigation. Public interest litigation is the strongest mechanism through which judicial activism is exercised very influentially in India. So I'm going to talk about the public interest litigation in my subsequent video. So I hope this video was liked by you, friends. If this video was liked by you, and if it was helpful for you in any sense, please tell me through the comment section. So thank you for watching my video, friends, and thank you for being very, very patient for watching this video. Have a very, very nice day.